Hello everyone and welcome to the Cour des Citoyens. The Court of Justice of the European Union plays a crucial role in interpreting the EU's anti-discrimination rules and deciding how they should be applied in real-life situations, and thus in a wide variety of situations. And so, the topic of our program today is the protection of citizens from disability discrimination in the workplace. In the second part of the program, my colleague Charis Pasiourtidou will join us to discuss some of the judgments of the court in this area. The Court of Justice, which is based here in Luxembourg, does not create social policy. The court explains how EU equality law should be interpreted and how it should be applied by national judges across all member states. As such, the Court of Justice has played a key role in making the principle of non-discrimination based on disability effective in everyday life. But what does that actually look like in practice? Let's take a few examples. In 2013, the court defined the very notion of disability as we understand it today in a case concerning two Danish citizens who were dismissed after repeated periods of sick leave linked to their disabilities. A year later, the court extended this definition to include obesity under particular conditions. We will take a closer look at this issue later on. Employees with disabilities might need reasonable adjustments to their working conditions. In 2022, the Court of Justice clarified what is meant by reasonable adjustments for employees with disabilities. It is not limited to simply adapting the worker's current position. The employer might be required to go further if possible and reassign the worker to another vacant position within the company. We're going to have a closer look at this too. To help us, I have invited my colleague, Charis Pasiourtidou, lawyer in the Research and Documentation Directorate. Hello, Charis, and thank you for joining us.
Thank you for having me, Adrone.
When we talk about the protection from disability discrimination, who is actually protected?
According to the court's case law, disability includes any limitation resulting from a long-term physical, mental, or psychological impairment, which, in interaction with various barriers, makes it harder for a person to fully and effectively participate in professional life. Illness, for example, whether curable or incurable, can become a disability as long as it entails such a long-term limitation. This is what the court said in its case of HK Denmark of 2013. And therefore, the concept of disability does not refer to an impossibility to exercise a professional activity, but to a hindrance, an obstacle to the exercise of such activity. By applying this definition in its later judgment of Karl Toft, the court said that obesity could potentially constitute a disability if it hinders the person's full participation in working life. This could be either due to reduced mobility or to the onset of medical conditions that could prevent the person from carrying out their work or causes them discomfort. And in this regard, the court clarified that the concept of disability does not depend on the extent to which the person may or may not have contributed to the onset of their disability.
What does EU law require from employers when an employee has a disability?
Under EU law, an employer has to make reasonable adjustments in order to enable an employee with a disability to participate and to advance in employment, unless such measures would constitute a disproportionate burden for the employer. But let's take some practical examples. For example, in the case of HR Denmark that we mentioned before, it concerned, as you said, two Danish women who were dismissed from their employment due to health reasons after not being able to work full-time. And in these circumstances, the court said that reasonable adjustments could take the form of reduced working hours to enable an employee with a disability who can no longer work full-time to work part-time. Now, it is up to the national court to assess whether, in the circumstances, such a reduction in working hours would constitute a disproportionate burden on the employer. The more recent judgment of HR Rail of 2022 concerned a trainee railway technician who had developed a heart condition and required a pacemaker. Now, this pacemaker made him unfit to work near electromagnetic fields like the railway tracks. And therefore, he was no longer able to perform the duties for which he was originally hired. But the court said that an employer cannot dismiss an employee with a disability simply because they can no longer perform the tasks for which they were hired. Instead, if the workplace cannot be adapted to enable the worker to fully participate in working life, then the employer may be required to reassign the worker, including a trainee, to another vacant position that is suitable to their competencies and capabilities.
And is there any recent case law, significant case law in this area?
Indeed, in 2025, the court issued a very important judgment in the Bervidi case. And with this judgment, it extended the protection against discrimination to employees who do not themselves have a disability, but who are subject to discrimination as the caregivers of another person with a disability. And this case concerned a mother of a minor child with a disability who was working as a metro station operator in Italy. And her work was subject to flexible and rotating working hours that made it really challenging for her to take care of her child. And therefore, she requested her employer to appoint her permanently to a position with fixed working hours to facilitate her caring duties. Her request was denied, and shortly after, she was dismissed from her employment. And in this case, the court confirmed for the first time that the prohibition against discrimination on the grounds of disability also covers situations of indirect discrimination by association. This happens when an apparently neutral rule, like a working hour policy that applies to all employees in the same way, places a particular disadvantage on an employee because of their association to a person with a disability, such as a child with a disability of whom they are the caregivers. And in these circumstances, the employer must take reasonable adjustments, must make reasonable adjustments in favor of such carers, such as adapting their working hours or reassigning them to another available position, always provided that these measures would not constitute a disproportionate burden on the employer.
Thank you very much, Charis, for your time and for this interesting review of some of the landmark cases.
It was a pleasure.
Thank you for watching us. You can find more Kuria Web TV programs on our website and on our social media channels.